Hello students, in today's session let us learn about general principles of drafting. As law students, you might have heard about legal drafting. Legal drafting is otherwise known as legal writing. As we all know, the central function of legal profession is to assist and promote the administration of justice and to render sound legal advice to the clients. An advocate has multiple roles to play as legal draftman, pleader, a counselor and a conveyancer rolled into one. An advocate has to communicate with his clients, advocates, courts and general public. As a legal draftsman, the advocate has to draft a multitude of documents like notice, plaint, written statement, interlocutory applications, petitions and documents with regard to conveyance. Legal drafting can be defined as the crystallization and expression of a legal right, privilege, function and duties. It intends to regulate the relationship with the parties. Importance of drafting in litigation is that it helps in meeting the client's goal and carries out client's instructions and to maintain the standard of care which protects the interest of the clients. Drafting helps in addressing before the court the grievance goes to the client. A draft is a rough sketch of a writing from which a final fair copy can be made. One who frames a document is known as a draftman. The nexus between language, facts and law should be fully understood before drafting any document. A good draft should be clear and simple words should be used. And if the document cannot communicate its intent in an unmistakable language, it fails to accomplish its purpose. The order in document should be logical and avoid repetition. After collecting ideas, facts and necessary information for drafting, sketch the document so that the ideas should be arranged in such a way that the final product should be clear. In planning stage, an advocate takes instruction from the client, analyze it, compartmentalize it and ascertain the purpose and object behind creating the document and do research on the existing laws. In the writing stage, he prepares a skeletal draft and create ideas for that and make sure that all the contents provided to him by your client has been incorporated in it. In the final stage, you revise the instructions, reorganize the material facts, rewrite it and edit it. The draft should not be vague. Each para should contain one major point. The draft of legal document should be framed step by step, containing a well-organized analysis of the problem. After finalizing the draft, the document should be typed on a good quality legal paper. There must be a margin of 4 centimeters at the bottom and left side and a margin of 2.5 centimeters to 4 centimeters at the right side and the top. Every page should be numbered. The number of pages should appear at the upper side, that is 2.5 centimeters from top and the side. The first page of the document has no page number. Each para should be numbered. All sheets of the document should be tied together by pinning or tagging. It is the ability of a lawyer to express the ideas in fewer words. Then only you can have the attention of the Honorable Court. You must be aware of the meaning of the exact words you are putting in the documents. Place yourself as a reader, read the document and satisfy yourself. For example, in a civil pleading, when a plaint is submitted by the advocate, it is the backbone of litigation in which the court proceeds. It is a statement of the parties in writing, setting their own contentions and claims. The rules for drafting of pleadings in India has been incorporated in various orders of Civil Procedure Code as Order 6, which mentions about the general rules of pleadings, and in Order 7 and Order 8, which specifies about the plain and written statement respectively. The pleading shall state the material facts and note the evidence. Likewise, what we have mentioned earlier, every pleading shall be divided into paragraphs and numbered in a chronological order. Each allegation shall be in a separate paragraph. Dates, sum and numbers expressed in pleading shall be in figures and in words. Every pleading shall be verified at the foot by the parties or by one of the parties. And the pleading shall contain the address of the parties for the purpose of service of all process of the court in that particular suit. And the address so furnished is known as registered address of the parties. It may be changed from time to time with the change in address of the parties, so that the information reaches the parties at proper time. And the court must be informed about the change in address of the parties at the same time by filling a form stating the new address. And when the registered address of the party is discovered by the court to be incomplete, false or fictitious, the court may its own motion or on application of another party order the stay of the suit, that is, if the address was given by the plaintiff. The court must be informed about the change in address of the parties at the same time by filling a form stating the new address. When the registered address of the party is discovered by the court to be incomplete, false or fictitious, the court may on its own motion or on application of another party order the stay of the suit if the fake address was given by the plaintiff. And on the other hand, if the fake address was given by the defendant, his defense will be struck off, which means that an order will be passed in favor of the plaintiff. In a civil pleading, the parties were known as plaintiff, that is, one who is filing the suit, and the defendant, the party against whom the case was filed. And if the plaintiff furnished the true address later and applied to the court for setting aside the order of stay, and if the claim is genuine, the court will set aside the stay order. If the defender later gives the correct address, the court will consider that application and his written statement will be admitted. As you know, the written statement is the objection filed against the plaintiff. Pleadings must state the facts and note the law. For drafting a plaint, the person should be familiar with the proper codes in which it is to be filed and specify the heading of the plaint, which specifies the name of the court. The heading should start with "Before the Honorable Court," then specify the court in which you are going to file the suit, and for that the pecuniary and territorial jurisdiction should be taken into consideration. Then the place in which the court is situated. For example, the heading should start with the name of the court in which you are going to file the suit, and for that the pecuniary and territorial jurisdiction should be taken into consideration, followed by the place in which the court is situated. For example, we can mention like this: before the Honorable City Civil Court, Bangalore. Then specify the address of the parties for the service of process from the court. Then specify the order and section under which you are going to file the suit. Then comes the content part, in which the skill, efficiency and more attention is needed. The advocate will state the claim of his client. The grievance goes to his client and how this court is having jurisdiction to try the offence. A good draft helps in addressing before the court the grievance goes to the client. He will draft that in clear and simple words, and the advocate must make sure that the document is able to communicate its intent in an unmistakable language to the court to accomplish its purpose. The prime duty of an advocate is to do justice to his client by drafting the pleadings or petitions in a proper manner, presenting it before the court in a clear language. Hope this section gave you a good insight on the general principles of legal drafting. Thank you.